Welcome to this edition of Real World Intellectual Property Podcast. My name is Stephanie Wilson, and I'm a partner here at Barons White Leonard. And with me today is Clyde Findley, who heads up our firm's intellectual property practice.
So hi.
Hi, Clyde. So Clyde is here today to talk about Intellectual Property 101, essentially the fundamentals of intellectual property and intellectual property law. And thank you for joining me. I hope you're ready to be on the hot seat.
You know what? I have no idea what I'm going to talk about, but I'm assuming you can tee it up, and I'll see if I can hit it.
All right. I'm going to start with the hardest question there is. What is intellectual property?
Yeah, that's actually harder than you might think. I think most people would say intellectual property is some kind of a property concept that is sort of abstract and in your head. It's intellectual. But there are a lot of aspects of intellectual property that are actually tangible, like copyright law. You're actually creating a work of art that can be a physical thing, like a statue or a painting or music. And in patent law, it's actual physical things, often mechanical devices that you're building. But at the root of all of it is the creative expression of some human that had an idea in their head, and they then turned it into something that represents that idea. And that's, I think, generally what intellectual property is. It's not real estate property. It's property created out of your head and expressed in some way. And there are several different branches of intellectual property, but that in general is the idea.
So when you mentioned there's various branches of intellectual property. So what are some of the examples? I mean, you gave some concrete examples, but what are some of those different categories?
Most people would say there are four. There's patents, there's copyrights, trademarks, and then trade secret. There's also kind of a fifth, which is a protection in your identity. Like, for example, Clint Eastwood recently sued someone for both trademark infringement and for misuse of his identity in the context of advertising. So you can protect your identity, especially if you're a famous person. So that's kind of a fifth area of intellectual property, but most people would say it's patent, copyright, trademark, trade secret.
So for a small business, like our typical clients, what are some of the areas of intellectual property that you're going to deal with them with, most frequently? I know we hear a lot about, they'll say, well, we want to protect our intellectual property. What does that mean? What are they trying to actually protect?
In almost any business, the most important thing, at least at first, is going to be the name of the business and any logos like this. Logos that we might use to associate the name of our business to the customer, to give the customer an idea of, this is us, this represents us, this is a logo, this is the name of our product, and it's a unique name that we want to protect because it really reflects the essence of our business and what we do. So the most important thing often is trademark or trade dress. It's how you portray yourself to the public.
Okay. So one example I was thinking of in preparing for our discussion today is like a can of Coke, right?
Yeah.
So you've got your can of Coke. You'll see the little R on there, the little TM on there, the little C on there. And obviously everybody recognizes what the can of Coke is. There's actual Coke inside of it. What's kind of the intellectual property that goes with that? Like obviously Coke they're protecting those secrets.
Yes.
Right? Like what, using that as an example, how would you kind of use that to describe intellectual property?
That's a really good example because it incorporates several different areas of intellectual property. One is that Coke stuff itself, and they protect that as a trade secret. They do not release the recipe for making Coca-Cola. It is kept somewhere private, and a lot of people have tried to duplicate it, and most people who are really good at tasting the difference would say, nah, that's not quite the same as real Coke. And when Coke came out with that new Coke back in, I guess it was the 80s, a lot of people had a problem with it because it wasn't the same as the original. So that original recipe is protected as a trade secret. It's locked up somewhere, and you have to have all kinds of protection mechanisms to make sure that you treat it as a trade secret. Otherwise, it won't be enforceable. So inside that can is a trade secret recipe, or inside a safe somewhere that made that thing that's in the can is a trade secret recipe for making Coke. So there's that. Then the can itself can be, although I don't think these cans, typical cans, are protected this way, but for example, I think the bottle for Coca-Cola, one of the original ones, can be protected as a design patent. There are different kinds of patents. There's a utility patent, which is what most people think of, a machine, a method of doing something. There's a design patent, which protects the shape, what it looks like, which is a lot like a trademark. Mm-hmm. So you can kind of think of a design patent as a lot like a trademark. So anyway, that can or bottle could be protected by a design patent. Then the look of it, in terms of the characters that are used, the word Coke, all of that is generally trademark. And that's the font that they use, the coloring that they use, the actual text, the characters can all be trademarked. And if it's a TM, that means they're trying to protect it. They're declaring that they are protecting it as a trademark. If there's an R, that means it's been registered, and they really do have a trademark on it, and you better not mess with it. If it's just a TM, you could theoretically still sue somebody, but it's a different kind of a standard and different kind of a case. And copyright also protects those things as well, because it's generally a work of art. The artwork that's on a can be considered a work of art and can be protected under copyright. So you've got design patent, you've got trade secret, you've got copyright, and you've got trademark all in that can, and you've wrapped it up all together in a good package. I like that.
So, all right, so if Coke was our client, or some other big company like that, right? How would they'd come to you, and obviously our smaller clients do too, but they said, okay, come to you, we have all of these types of intellectual property we want to protect. How is that protected? So I guess maybe let's start with the trade secret. You mentioned it's got to be locked away. You have to take certain steps to protect it. What are those steps or procedures you need to follow to protect your trade secrets?
It's probably customized for every trade secret. Like you might do software differently because software has to be accessible by the developers, and then maybe a recipe has to be protected and maybe accessed only by certain people that are actually putting together the syrup that makes Coca-Cola. So it's going to be slightly different, but the basic idea is that if it's going to be a trade secret, you have to treat it as a trade secret. And if you try to assert that someone stole your trade secret, you better be able to prove that you treated it as a trade secret, and this person that you say stole it didn't just like walk in and take it and walk out, that there was a lot of procedures that someone had to go through in order to get access to that secret before they took it. So it's a proof problem that you end up having to argue in court later. So to protect a trade secret, all you have to do is treat it as a secret, and that can get sort of customized based on how it is. So you don't have to go to the government to get a trade secret. You do it by yourself, by the actions that you take to protect a trade secret. For everything else, you pretty much have to go through the government and get some kind of a blessing that what you have is protectable. So for a trademark, trademarks and copyrights, you can build up trademark rights without going to the government. You can get what we call common law rights just by using a trademark or by using something that you create yourself, a work of art. You have common law rights in those things, in copyright and also trademark. But if you want to really assert those against someone else and really protect yourself, you need to go through the registration process for both trademarks and for copyright. For the trademark one, there is actually a trademark examiner who will look at your proposed trademark, which can be just the words of something or the logo, what it looks like and color and all of that. The trademark examiner will analyze everything and look at whatever else has been tried to be protected. Sometimes you have to modify things and go back and forth with the examiner to get full protection of a trademark. With a copyright, generally there isn't much of an examiner. You just have to record your work of art, send it to the copyright office, jump through some hoops in terms of forms that you fill out and things that you pay, and then you wait and you get a copyright registration. Both of those give you a fairly strong right to sue somebody else if they're using your trademark or your copyrighted material. And we take clients through those processes all the time.
Is that a very complicated process for trademark and copyright?
Compared to patents, no. It is sometimes a little bit daunting for somebody who has never done it before. It is theoretically possible for someone to do their own trademark application and their own copyright application registration. You don't necessarily need a lawyer for those things, but you probably should, especially if you're a business, just to make sure you don't mess it up. But it's not all of that complicated, especially compared to the patent world. Patent world is incredibly arcane, old, uses a whole different language. There's a whole bunch of nerds over there. And if you're going to try to get a patent on an idea that represents an invention, there's going to be someone generally with a master's or PhD level on the other side of the fence at the Patent and Trademark Office, examining in detail everything that you claim about your idea and trying to show you why you're wrong and someone else has done it before you, and you're not deserving of any kind of a patent protection at all. That's a very different kind of animal and takes a lot of work, and you really should get a patent attorney to help you do that, although you don't have to, but you really should.
How long do those protections last for? I mean, I seem to remember from my law school class that copyright has a lifespan, essentially, right? Is that true for all areas of intellectual property?
Well, it depends. For things like patents, it's generally 20 years from the date of filing of the patent application. It didn't used to be that way. It used to be that you could stretch things out a little bit, but now it's 20 years. Although in the patent world, you can file what are called continuation patent applications, and you can, in some cases, especially if you're adding new features to your invention, you can get a continuation in part application filed and get your 20-year date from that new filing date. So, but generally patents will expire 20 years after they are filed, after the application is filed. For copyrights, I forget exactly, but it's a long period of time after the life of the author. And for trademark, basically as long as you're paying for it and using it in commerce. Those things can go abandoned after a while, but you can maintain the trademark protection for something as long as you're using it in commerce and as long as it's reflective of a brand or product that you are actively selling or using as a service, that kind of thing.
So you, referenced that, one of the reasons that you want to get these protections, right, like get a patent or a trademark or any of those things filed with the appropriate office is it's basically to protect, I guess, your own ownership of that intellectual property. So what recourse do you have if someone is violated, is copied, you've designed something, you have a patent, you've developed something, and somebody comes along and they copy that, or somebody's using your copyrighted material. What recourse do you have there?
Well, ultimately, it's the court system. Most people will go through a sort of cease and desist process where you write a threatening letter. You get the law firm to write a letter, and you yell at somebody, and you try to negotiate some kind of a deal, some kind of a license or a settlement or an agreement not to use or to stop using whatever it is you don't want them to use. But assuming all that falls apart and you can't settle it, then it's the threat of litigation. And that's whether you go into litigation is a difficult analysis. It's very expensive generally, so the thing that you are protecting needs to be worth it. And so, and if the other side is going to fight back at all, then you really have to evaluate whether you're going to get into that world or not. It often turns out that those kinds of battles take a long time. They cost a lot of money. Generally, they involve a lot of experts. and a lot of discovery that you're fighting about all the time. And in my experience, occasionally the outcome is very good for one side and not for the other, but for the most part, nobody likes the outcome. Nobody, because the person, the side that owns the intellectual property had to pay a lot of money in order to enforce it. And at the end, most of these cases never go to trial anyway, so you don't get a full-blown win. You get a settlement agreement that you really could have negotiated way in advance, but because of the emotions and because of not a full grasp of what it was that someone was actually doing to copy, maybe they developed it on their own, maybe it's not quite the same, and there's a lot of arguments about those differences. You end up finding, you end up coming to a settlement agreement, and if you had just known ahead of time all of those facts, which you discovered during the discovery process, you probably could have settled it, but and you dove into the litigation side anyway. And so often I will really challenge someone's desire to go sue that person for infringing on my patent or copyright. Okay, let's talk about that and go through what it's likely to happen at the end a year or two from now and how much it's going to cost to get there, and do you really want to do that? But just the short answer to your question really is you either negotiate a settlement or you go to court.
So if it is, recognizing those difficulties to, and again, maybe, like you said, ultimately you may still be successful at the end, but it's going to cost you a lot of time and money and resources to get there.
Right.
But obviously I think we would still recommend that people do take the steps to protect, their intellectual property, right? I mean, what are, I guess, some of the tips that you would have for maybe a newer business starting out as they're starting to think about, a lot of times they'll be thinking about, contracts they're entering into with vendors or customers or clients, and, how we're going to pay our employees and all of that stuff. They're not necessarily thinking about all the intellectual property that they may want to protect as part of their business. But what are some things that you would advise a new company at least think about when they're getting started?
For a brand new company, and I'm just going to kind of make up in my head some brand new company. I have no idea what they're selling, but at first, I would advise a business owner to do a lot of just Google searching and convince themselves that the name of their company and the name of any product that they're going to sell is relatively unique, and the probability that someone is going to come up with something that is very similar soon is pretty low. And once they have done that, then I'm happy with respect to their trademark protection, at least for a while. They haven't filed any registrations, and I don't necessarily care about that. It's a good idea that they do, but if they don't have that startup money and they're relatively confident that they're in a new world, a new name, a new product area, I would just want them to behave as though they're in a sophisticated world and just start doing business. At some point, when they start making money, maybe that's in 6 months, a year, 2 years, and they are still convinced that no one else is starting to infringe upon their name and their product, their branding, then they probably should start getting together a trademark application for all the different things that represent the brand of their business and their products. If they're in a world where they're inventing something, then it makes sense to think relatively early on about several things, and the most important one initially is to make sure that the employees that you have hired are hired to invent the thing that you want to protect. So you don't necessarily have to do any patent applications yet, you don't have to do any copyright registrations yet, but you have to make sure that those people that you hire have a duty to assign all of their inventions to you now, right when you hire them. If you don't have that in an employment agreement, then you may find that you don't own what you think you own when you want to try to protect it. So Number one, think about trademarking and naming and all of that. Number two, get your employees to assign any intellectual property rights that they may develop during their employment to you right now. Then go off and do all your inventing and just do it in a relatively secret environment. If you have to bring in somebody that looks at your invention like it's going to, someone who might invest in it, do that under an NDA, non-disclosure agreement, so that you don't go public. I don't want an inventor to go public without having some kind of serious plan for protecting any invention there. But assuming that you've got someone who's working for you that is hired to invent, go off and do your thing, build your product, get ready to go. Don't go public until you have a good plan for protecting with a patent application or a copyright registration. So you can kind of be free to run your business for a while, as long as you're relatively knowledgeable about what's going on out there in your business space, and you're not stepping on somebody else's rights, and the probability of someone else stepping on your rights is relatively low. I'm happy with somebody running around doing that on their own for a while, but once you start making some money, you really need to get the lawyers involved and to protect your intellectual property rights, and especially if you're hiring someone, to get someone covered by an employment agreement that's going to protect you.
Great. I think that probably covers a lot of the basics. You know, we've touched on what the 4 or 5 different types of intellectual property are, how you protect them, and why you should want to protect them, and kind of what that process is. So thank you for joining me. I think it's a great discussion, and I will see you the next time.
Thank you.
On the Real World Intellectual Property Podcast.
All right. Thanks.
Thanks.